Ontario court overrides French order. Child prohibited from traveling to France to visit his father. The mother and father in this case were married in 2008 and have a child together who is now 10 years old. They divorced in France in 2012, with the child having primary residence with the mother. The father had extended visitation rights. In May 2016, the court in France granted the mother's request to move with the child to Toronto under a parenting order. The mother had remarried and has 2 other children, and the child was living with them in Toronto. The father's visitation rights were adjusted so that he could exercise them in France during the child's school breaks, summer holidays, and with the child traveling to that country to make it possible. Under the parenting order, the child was scheduled to travel to France soon to spend time with the father. However, due to COVID-19 pandemic, the mother was currently concerned about the child making that trip. The mother brought an urgent motion requiring the father to exercise his parenting time with the child in Toronto instead of France for as long as the Canadian government advisory against all non-essential international travel, quote, the travel advisory, remained in effect. First, the court addressed the matter of its own jurisdiction to make the order. Under the Children's Law Reform Act, it had authority to make an order for custody or access if the child is habitually resident in Ontario, which since 2016 the child had been. Moreover, the parenting order made in France qualified as an order that was enforceable here in Ontario. The next question was whether the Ontario court had the power to supersede a parenting order made in France. The test in Ontario was that the court was satisfied there had been a material change in circumstances that affect, or is likely to affect, the best interests of the child who habitually was resident in Ontario when this application started. Again, the court was satisfied that the current COVID-19 pandemic satisfied that test. It ordered that the French issued order could be varied on a temporary basis. The court said the following: at this time, given the travel advisory remains in effect, traveling to France raises unacceptable risks to the child's health and safety, and is not in her best interest. It is worth noting that the government of France continues to restrict entry into that country by foreigners. While this would not apply to the child who is of French citizenship, it demonstrates that governments continue to place stringent limits on travel and entry to minimize the risk of spreading the virus. If she were to travel to France, the child would be taking a lengthy flight, unaccompanied, on a commercial airline. The mother was unable to obtain assurances of any additional measures in relation to unaccompanied minors on either Air France or Air Canada. The mother's evidence is that Air France, only children 11 years of age were required to wear masks. The father submits that precautionary measures, such as wearing a mask and social distancing, would protect the child from any risk during an international flight. However, this was far from certain. A Government of Canada advisory shows 19 international flights with confirmed COVID-19 cases since July 1st, 2020, including an Air France flight from Paris. Moreover, the transmission of COVID-19 has been proven difficult to control, including in settings where masks or other protective equipment are worn. Traveling to France on a commercial airline and transitioning through the airports would unnecessarily expose the child to risk of infection. While both parties agree that the child is capable and responsible child, it is not reasonable to expect that a child her age would be able to take all the necessary measures over such a lengthy period of travel time. In addition, the mother has verified with her employer that the child would not be covered by her employee health benefits plan while in France. She would have also had to self-isolate for 14 days upon returning to Canada, which could impact her ability to attend school at the beginning of the school year. The court also rejected the father's claims that the mother was using the pandemic as a pretext for keeping the child from him. The mother had been cooperative in facilitating access on numerous occasions in the past and had offered to pay the cost of the father's travel to Toronto if he wished to exercise access here. The court also noted that a temporary ruling was not intended to minimize the importance of the relationship between the child and the father's extended family in France. The court added that in current circumstances, where the COVID-19 pandemic continues and travel advisories remain in place, the child's health and safety cannot be put at risk. When inquired about whether the father is able to travel to Canada, he advised that he was applying for a passport, but would not receive it for approximately 3 weeks. He will be required to self-isolate for 2 weeks upon arriving. In addition, while he has been working from home until May 2020, he is required to return to his workplace in early September 2020. The court recognized that requiring the father to exercise his parenting time in Toronto is not ideal. It's in the best interest of the child. The court expects the parties will continue to cooperate to facilitate access by the father through telephone and video calls with the child, and in the event that the father travels to Toronto, to ensure a reasonable make-up time for lost parenting time. What do you think? Did the court get it right in this case? Thank you for watching. If you like this video, please give us a thumbs up. You can subscribe, share, and comment below. Until next time, I'm Russell Alexander.